In this final lesson, examining the basic concept of the trust, what we're going to do is make a clear delineation between the idea of a power and the idea of a trust. And this gets us into a little bit of the details relating to some of the different kinds of trust that can exist, or at least some of the kinds of trust that exist on the basis of the kinds of authority that are given to a trustee who is then going to essentially deal with the property which is being held on trust for the beneficiary. But then afterwards, we're going to start to talk about the creation of the express trust, namely looking at the three certainties and looking at the different ways in which the three certainties apply to either this idea of a fixed trust or a discretionary trust. So, essentially, in this lesson, we're going to spend some time examining the delineation that is made between the use of a discretionary trust and the idea of a power. And the reason why this is important is because sometimes you can look at a trust instrument, or you may be able to look at a problem question, and you might struggle to clearly delineate between what a discretionary trust is and what a power is. And so the point here is to have a look at this in more detail. So there are a lot of similarities which are had between the idea of the discretionary trust and certain powers which can exist in relation to a property which is being held on trust. Okay, so it's not all powers, of course, but in certain circumstances, you can have a look at see a trust power that is very similar to just the idea of a discretionary trust. So the key delineation here is, of course, this idea between a discretionary trust and the idea of the power of appointment. And the reason why there are a number of similarities is because, for example, in both instances, there is the ability for the individual in question, i.e. the person who is in charge of the property, who takes legal title of the property, to essentially distribute assets to beneficiaries. So one of the things that we know when we talk about the law of trusts, at least in the creation of the express trust, is that you will have a settlor or a testator who will then transfer legal title to the trustee, which is sometimes known as having proper constitution, which we will get to in a future topic. They go to the trustee then holds that property on trust and has legal title to it, whereas the beneficiary has equitable rights in that property. And of course, it is the trustee who holds that property on trust for the beneficiary. And in a discretionary trust, and in some circumstances when we talk about the powers of appointment, there are similar key similarities in terms of the ability for a trustee to be able to distribute assets to a beneficiary. What then are the key differences between trusts and powers? Well, when we talk about a discretionary trust and the delineation and distinction that is had to the idea of, for example, the power of appointment, when it comes to the discretionary trust, the idea of distributing assets to the trustee, to the beneficiary, should I say, in terms of property, is an obligation. Okay, it is a requirement for a trustee to distribute the property given in the prescribed discretion. So essentially, what a discretionary trust does is give the trustee a certain amount of power in terms of, or at least a certain amount of authority in terms of their ability to distribute assets, and they may be able to distribute assets to at their own discretion. But the requirement to distribute the assets is not one that they have any kind of say over. They have to distribute the assets, but they may be given discretion over how to distribute the assets. For example, maybe the settlor or the testator holds the property on trust. Let's say that's a lot of money that they hold on trust. They give this to the trustee and they make a big old list of beneficiaries. And let's say the beneficiaries are a number of charities, 3 or 4 charities, okay? And they say you can distribute this property to these charities in whatever way you see fit. And the trustee may then have the discretion to go ahead and distribute some to this charity, maybe a little bit more to that charity, maybe a little less to that charity, etc., etc., etc. But the question here is, in a discretionary trust, there is an obligation to do that. There might be a prescribed amount of discretion in doing so, but the actual requirement to do it versus not to do it in a Shakespearean manner is actually to essentially you have an obligation to do so. When it comes to a power of appointment, this same obligation may not be present. And it means that if you have a power of appointment which is not exercised, essentially what happens is you have a default of the appointment, at which point the property goes back to the original ownership. A further distinction between trusts and powers is this idea of there existing some kind of fiduciary relationship. A fiduciary relationship, for those of you who are unfamiliar with the key terminology, is simply a relationship of trust. It is one of trust. So you can have fiduciary relationships that exist in all kinds of circumstances. A company director may have a fiduciary relationship to the company's shareholders. A solicitor may have a fiduciary relationship with their clients. The concept of a fiduciary relationship, however, also arises in the case of a trust, namely between the trustee and the beneficiary of the trust. What happens there is you have a trustee who holds the property that has legal title, that has equitable, and the equitable rights exist in the process of the beneficiary. And of course, the trustee has a fiduciary relationship and a fiduciary obligation towards the beneficiary in some way. When it comes to powers, this kind of relationship may be fiduciary, so you can have powers of appointment which have fiduciary attachments to them, but you could also have ones which are just simply personal relationships in nature. And so let's just finish on a case which illustrates some of these points in a little bit more detail. The idea of the case of Mettoy Pension trustees from 1991. In this case, we have a certain pension fund scheme where essentially if there was an additional surplus of funds in the corporation, this could be applied at the discretion of the employer. So the employer has a certain amount of discretion, and essentially what happens here is the discretion that exists is this idea that if there is additional surplus, you have the discretion to do with that what you see fit. When the company then went into liquidation, the benefits from this surplus stood at a hefty £9 million, so quite a significant amount of money. And what the issues were that the court had to consider were twofold. The first question that the court had to consider was whether or not the beneficiaries were entitled to discretion, i.e. whether or not the power was a fiduciary power, whether or not it had some kind of fiduciary relationship. And then the second question is whether or not the exercise of the power can be done by a liquidator in the process of insolvency. We won't get into the concept of insolvency law in this lesson, but essentially one of the things that happens when we have the winding up of a corporation, whether that be voluntarily or through court discretion, you may have a situation where a liquidator then goes about distributing assets to creditors in the way that they see fit. And there's lots of different rules, lots of different principles that relate to that. But the question here was, could this power of discretion to distribute these assets be done by the liquidator in the process of insolvency? And it was held that in answering the first question, the power was fiduciary, so the beneficiaries had discretionary rights to that property. In answering the second question, it was held that the liquidator actually had no authority to exercise the power since the assets were not held by the company. They were held by a pension, under a pension scheme held on trust. However, the power was therefore able to be enforced by the court.